Bom dia a todos, sejam muito bem-vindos aos que estão nos acompanhando aqui online. Nosso webinar Soluções de conflitos em seguros e resseguros e o papel do PRICL, uma matéria super interessante, vai se iniciar agora. Antes de passar por os nossos ilustres palestrantes e debatedores, eu gostaria de fazer um disclaimer da Fundação Getúlio Vargas, e vou ler o textinho para após termos a confirmação aqui de todos. As manifestações expressas por integrantes dos quadros da Fundação Getúlio Vargas e por convidados que participam dos eventos e transmissões online representam exclusivamente as opiniões de seus autores e não necessariamente a posição institucional da Fundação Getúlio Vargas. Reiteramos também que todos aqui presentes concordaram em participar desse evento de forma espontânea e, com isso, autorizam o uso de seu nome, voz e imagem, além de ceder os direitos autorais patrimoniais relativos à sua exposição para essa transmissão, que ficará disponível posteriormente nos canais oficiais da FGV. Para seguir com essa transmissão, pedimos que se manifestem verbalizando ou sinalizando a sua concordância. Todos de acordo? Podemos iniciar? Bom, vamos lá. Antes de tudo, eu gostaria de fazer a apresentação, né, do nosso palestrante, dos nossos debatedores. Primeiro, gostaria de apresentar aqui o nosso palestrante. Vamos iniciar pela manifestação dele, professor Helmut Heiss. Desculpem aí pela pronúncia, que talvez não seja a melhor. O professor é referência na área que vamos tratar hoje, é reconhecido por todos na área, professor da Universidade de Zurich, e vai nos trazer aqui os apontamentos sobre o PRICL. Na sequência, vamos passar para os debatedores, iniciando pelo professor Sérgio Barroso de Mello, que é vice-presidente mundial da AI, da Associação Internacional de Direitos de Seguros, advogado formado pela Universidade Federal do Rio de Janeiro, pós-graduado em Direito Empresarial pela UF e em contrato de resseguro pela Universidade de Santiago de Compostela, na Espanha. Professor convidado dos cursos de graduação e pós-graduação em Direito de Seguros e Resseguros da Escola de Negócios de Seguros, da Pontifícia Universidade Católica, PUC, da FGV e da Universidade Federal do Rio de Janeiro. Ele é membro do grupo responsável pela elaboração dos princípios de contrato e resseguro, o PRICL, nosso objeto aqui, vice-presidente mundial da Associação Internacional de Direito de Seguro, como já falamos. Na sequência, vamos ao professor Ilan, que é nosso professor visitante aqui na Escola de Direito da Fundação Getúlio Vargas, é doutor em Direito Civil pela Universidade do Estado do Rio de Janeiro, a UERJ. Na sequência, o professor Marcelo Mansur, que é sócio do Matos Filho Advogados, professor da Fundação Getúlio Vargas e membro do Instituto de Inovação em Seguros e Resseguros, também aqui da Fundação. E, por fim, vamos ao Bernardo Neto Arruda, que é diretor jurídico do IRB, trabalhou como advogado no Pinheiro Neto, e trabalhou também em escritório de consultoria tributária, Branco Consultores, atualmente trabalha no jurídico do IRB, já há bastante tempo, ocupou cargos como coordenador jurídico, gerente jurídico e atualmente cargo estatutário de diretor jurídico, sendo inclusive diretor estatutário do IRB, responsável pelo relacionamento com a SUSEP. Bom, vamos lá iniciar o nosso nosso debate aqui nessa área tão interessante e com tantas mudanças em curso, que é a área de solução de conflitos, né? O professor vai trazer aí as perspectivas do impacto dos princípios do PRICL dentro da solução de conflitos, e vamos passar por áreas como arbitragem, também outros impactos relacionados ao tratamento de disputas na área de seguros e resseguros. Professor, seja muito bem-vindo, estamos aqui todos atentos aos seus ensinamentos. Fique à vontade.
So hello, everybody, and thank you, Juliana, for the introduction, and thanks for the invitation to this event. I'm extremely glad to talk to you today. I'm extremely glad having had so many friends in insurance and law in Brazil so far, and probably gaining more today. That's wonderful, and it's wonderful to be able to present on a project that has been going on since years now, and will most likely be finished ultimately by next year. And this is the topic of today, which is the principles of reinsurance contract law, and we abbreviate them with the PRICL. The subtitle says a new reinsurance contract law, and the answer to this subtitle is clearly no. It's not going to be a new reinsurance contract law. It's quite fancy today to say that you are a game changer, but there is not really an intention to change the game, followed by the project group on the PRICL. Rather, we are looking at ourselves as a project group that tries to provide an instrument which will enable improve the application of reinsurance contract law as it exists today and as it is expressed in an international trade custom, if you want it this way so far. Looking at the table of contents of what I will present to you, I will talk about the concept of the project, which deals mainly with contract certainty, legal certainty, and uniformity, and of course with the possibility of globally applying those principles. I will then go into some historical remarks, how this thing has developed, because as always, such projects come from certain circumstances, very often also by coincidences, not necessarily by plans that had always been there. So that may be of some interest. And then I will go into the contents of the PRICL, the characteristics of the PRICL, and how we're going to try to implement them in practice. This means the way forward, especially through arbitration and choice of law clauses. And then we look for what is the targeted benefit of the PRICL. And for further information and so on, I'll give you some links and some contact details. This here, in my view, is the most important part of my presentation, which is the concept of our principles of reinsurance contract law. And I always state that we are dealing with contract certainty, with legal certainty, with uniformity of the law, and with a global application of these principles. If you allow me, I will start with contract certainty. That is something that has been fostered by supervisory institutions around the world. And those institutions try to do away with this handshake mentality that governed reinsurance for a long time. And they wanted contracts to be properly drafted and all mutual obligations to be written down in a contract document that is structured, and thereby contract certainty would be provided. Now, if you write down a contract, of course, you make it more certain and you make the contents more easily and more readily available to any reader and also to arbitrators in an arbitration proceeding. However, it's not at all clear that the parties have used clear language and transparent language and that you would understand the clauses. And if you look at COVID-19 cases, we all were involved in many situations where it was very doubtful what the parties meant when they mentioned that aggregation was done by event. And the event definitions in the contracts were not so clear very often. And so one purpose of the PRICL is to improve contract certainty by giving definitions for certain terms used in contracts and explain them in comments and illustrate them by examples. If, for instance, a contract is subject to the principles of reinsurance contract law, and the parties in their contract have an aggregation clause referring to the event as the aggregating factor, then the term event will be defined by Article 5.2 of the Principles of Reinsurance Contract Law. That the definition will depend what type of reinsurance contract we are dealing with. And once you have this definition, we hope it's already helpful. If there is still some doubt, you read the comments that explain the definitions. And if you still have doubts, you read the illustrations where we have provide examples, cases where the event definition would apply and others where it wouldn't apply, so that you could sort of check your case as compared to the cases stated in those illustrations. So we hope that by these definitions, comments, and illustrations, contract certainty would be improved. Now, many issues are governed by law, not necessarily by the contract. One of these issues would be remedies for breach of any type of duty. The principles of reinsurance contract law assume that there is a general duty of utmost good faith that lives throughout the period of the contract, from contract negotiations all the way until the contract ends, and the relationship between the parties will be governed by uberrima fides, by utmost good faith, and a breach of any of the specific duties deriving from utmost good faith will lead to the application of certain remedies. And the PRICL are defining those remedies in line with more modern developments, especially in English law, and applying the principle of proportionality of the remedies as compared with the severeness of the breach and the effects of the breach. And if you choose the PRICL to govern your contract, you will have clarity as to the remedies, and this will put you in a situation of legal certainty. Again, I'm not claiming that the PRICL provide 100% legal certainty, but certainly they are improving the degree of legal certainty that is very often missing today, because we lack, in many jurisdictions, we lack reinsurance-specific rules, and this lacuna is being filled by such legal rules of the PRICL. The third point, the uniformity, is particularly important when you interpret the reinsurance contract. It has been said, for instance, with a view to follow the settlement or follow the fortune clauses, that one and the same clause used in a contract governed by English law may be interpreted in a very different way than as it was subject to the law of New York. This has been expressed in a practitioner's handbook on reinsurance law by a law firm that is now Clyde & Co. And it says a follow the settlements clause, for example, just one example, may have a very different meaning when it is interpreted in the light of the law of New York rather than that of England. Now, if that's true as between New York and England that belong to the same legal family, an Anglo-American legal family, it should be even more true if the same clause would be subject to Brazilian law or to Swiss law. And this has simply to do with the fact that usually contract clauses are interpreted in view of the background law under which they are negotiated. And there's big differences. English law, for instance, does not accept a general duty of to follow the settlements, whereas Swiss law, for instance, has a very strong duty to follow the settlements, even if the parties do not agree on a follow the settlement clause. So depending on whether English law or Swiss law governs the contract, a follow the settlement clause in the contract may be looked at very differently from a Swiss law perspective and an English law perspective. If you have one and the same clause and at the same time you apply the PRICL as the background law, then you will have a uniform standard of interpreting follow the settlement clauses, and this will lead obviously to a more uniform application of the clauses as they are used in the market today. And I would think that improves predictability of results, and that should be something parties would be interested. And finally, we were looking for the creation of a set of principles that could serve as a global reinsurance contract law. We were not looking for European principles or civil law principles. We were looking for something that could be applied everywhere. And as it has been the case, always been the case, reinsurance is usually subject to arbitration, and arbitration is something that is more or less global, and arbitration reinforces this intention to have a global set of rules that PRICL themselves say they want to be applied when the parties to the contract choose them as the applicable law. And that's one thing. The fact that the PRICL are saying this is one thing, but the PRICL themselves is a piece of paper written by professors and some practitioners, none of which holds legislative power. So mentioning that they will be applicable once they are chosen is something that is soft law. That's not hard law. That's not binding. So the question is, can you somehow enforce it by means of hard law? And the answer is yes. We have a model law provided by UNCITRAL on arbitration, and Article 28, paragraph 1 of this model law says that the parties to an arbitration can choose the law applicable, and they cannot only choose some state law like Brazilian law or Swiss law or English law, they may as well choose principles of law. There it is expressed as rules of law. And the PRICL actually would qualify as such rules. So if you submit your reinsurance contract to arbitration and have the seat of arbitration in a country that follows the UNCITRAL model law, which is very often the case, you will have the possibility to choose the PRICL as a law governing your contract, and that would equal state law like Brazilian law or Swiss law or English law. And then the final answer, the final question is, what do PRICL contain? They contain reinsurance specific rules. The issues I've mentioned: follow the settlement, aggregation, back-to-back cover, and so on and so on. Those are all reinsurance specific issues, but they do not govern questions of general contract law. And you may say now, well, but how can you provide a uniform and global set of rules if, after all, the general rules on contract law are so important also for reinsurance contract? Because take, for example, how do you interpret a contract? What's the method of interpreting contract terms? This may be very different from jurisdiction A as compared to jurisdiction B, and it may influence the outcome of a reinsurance contract very tremendously. So even if you have reinsurance specific rules, you may still not have a uniform reinsurance law due to the underlying general principles of law that will still remain to be national. But that's not true with the principles of reinsurance contract law, simply because under Article 112 of the PRICL, it says that all the issues that are not settled specifically in the principles of reinsurance contract law shall be settled in accordance with the UNIDROIT principles of International Commercial Contracts 2016, the PICC. UNIDROIT, as you know, is an intergovernmental organization seated in Rome, and they deal with the unification of private law. And for a long time, they have prepared those PICC as a general commercial contract law. And if you choose the PRICL, you choose as well as an underlying general contract law, the PICC, and the two together form one package. And this means you opt completely out of national law, and you opt completely into a transnational set of contract law principles. And that will give you a uniform and global system of reinsurance contract law. Now, how did we come up with this idea? And the answer is, well, we were nudged. I think you call it in a more modern way. The truth is that around the year of 2014, when people observed that there was a group working on principles of European insurance contract law, principles that were excluding reinsurance from its scope of application, and principles that were only applicable in the EU. When people were observing this, there were two colleagues contacting me, two practitioners contacting me, one from Switzerland, from the reinsurance industry, and one from the UK, equally from the reinsurance industry. And they said, hey, you're doing those principles, that's interesting. You know what? We need that in reinsurance. And I asked both of them. I said, you call me because your Swiss colleague has called me. And the UK colleague said, no, I am not aware that the Swiss colleague has called you. And the Swiss was not aware of the UK intervention. So I figured, well, if two people from different parts of Europe contact me about the same time on there being a need in reinsurance contract law, there must be something about it. And this gave rise to the idea of setting up another project group that would take up the way we drafted those principles of European insurance contract law and transform the idea into the area of reinsurance. Now, when you do that, you need a lot of participants and they will cause travel costs and so on and so on. So you need money. So we applied in 2015 to the Swiss National Fund, to the German Research Association, and to the Austrian Science Association and the Austrian Science Fund. And we received funds from all these three institutions, and that allowed us to start the whole project in 2016 with a first workshop. We set up two groups. One was what we call the Principles Drafting Committee. That is a group of academics. They are independent and they have the ultimate say on what's in these principles, because we figured that it's necessary to take the knowledge of practitioners, but we could not leave the drafting of the rules to practitioners, because then the markets would consider them as being biased in one way or the other, depending on who would draft the principles. On the other hand, academics could not just write down rules on reinsurance contract law. So we needed the discussion and the impact from practitioners. And so we set up advisory groups, one advisory group with members from the reinsurance industry, and another advisory group with members from the reinsured side, the insurance industry. And of course, we also called in brokers, reinsurance brokers. And we had workshops where we presented drafts and we discussed it with the practitioners. We got in all the different views of the practitioners, and then we sat down and we revised our principles. And that led to the publication of the PRICL, what we called 1.0, because we knew this is not going to be the final version. So we called it 1.0 in 2019. You see the copy of the front page ahead of this green arrow, and you have them available for free on our website, on our PRICL website that I will show in the very end, and also by the UNIDROIT website. And you can, as I said, freely download it. From 2019 on, we have been working, we continued to work, and we will finish the PRICL 2.0, and that will be the final draft in 2024. And we will publish them again, open access for everybody, so you can just download it all from our website. Now, if you look at the contents, I would just like to outline the contents of PRICL 1 and PRICL 2, and then say a word about the structure of the different chapters. In PRICL 1, we have chapter 1, that is the general principles. This is how you apply the PRICL, how you interpret the PRICL, what's the relationship of the PRICL with traditional trade custom, and so on and so on. And as of chapter 2, we go into reinsurance specific contexts, mainly the duties of the parties, as I said, utmost good faith, pre-contractual disclosure, duties in the context of claims handling, duties during the contract period, and so on and so on. And chapters 4 and 5 deal with very important questions, as you know, with issues of allocation of losses and with issues of aggregation of losses. We have put these together in a small brochure. I would love to hand them out to you, but obviously this is physically not possible today. The PRICL 2.0 will add what is written in red here. They will add a chapter on cover, and this chapter on cover will have one section on back-to-back cover, one section on retentions, one section on XBL and ECO, and then another chapter on duration, general issues of the duration of the contract, and then special reasons for terminating a reinsurance contract. And that will be the overall PRICL work. Now, if you go into if you look at the PRICL and you look at the structure, then every chapter is subdivided in sections, and in each section you find articles. This is done the same way as UNIDROIT has done it with its principles of international commercial contracts. What is most important to me is to tell you that, first of all, you find there rules that are written like you have it in a civil law world, in a traditional codification of a contract, of contract law, and which in Brazil, of course, you are most familiar with. And I think that's already an added value, at least for the civil law world, in the area of reinsurance contract law. Now, we all know that once we read an article in a law, we always look for guidelines on how to interpret them. And so we have written comments that would explain the rules. And in addition to those comments, we give illustrations. We always provide examples, usually examples that have already been dealt with in some state case law and published case law, mostly English case law or US American case law. And we tell the reader on how this case would be solved under the specific rule of the PRICL, and we tell in which cases the PRICL would lead to result A or result B being applied, yes or no, the remedy being granted or not being granted. And so if you have a case in practice, you could sort of compare your case with those illustrations and find your way and do a good judgment on which way an arbitrator would apply the PRICL in your case. So I think that's the most helpful thing, that we do not only give rules, but also comments and illustrations. Now, if we look into the characteristics of PRICL, I would like to point out a few things as compared to other sets of principles that you may be aware of. I've been talking about the PRICL, the Principles of European Insurance Contract Law, before, and you may be aware of the fact that in the US you have many restatements, and recently there was another restatement that is called Restatement on Liability Insurance. And you may say, well, they are all very similar because they all give rules as though that was a law, but it's just soft law. It's written by academics, practitioners, not by legislators. But then they give comments explaining the rule, and then they give illustrations showing how the rule would apply in practical cases, to practical cases. And indeed, they are very similar in the way they are structured, and they are very identical in one point. Each of them is a soft law. None of it could ever be hard law as long as they are drafted by private persons. But the most important difference between all of them is who is the addressee of the respective principles. In the US restatements are mainly directed towards the courts because they try to sort of discern common principles of, in this case, liability insurance law throughout the United States, the various jurisdictions in the United States, and thereby they would like to nudge courts into more uniformly apply the common law of insurance contracts in the US. The principles of European insurance contract law were clearly addressed at the EU legislator, even though so far the legislator didn't follow. The idea was that by giving a uniform set of insurance contract law rules, insurance companies would be enabled to sell their contracts cross-border without any boundaries. Today you have a problem. If you sell a German insurance contract into France, then French law will most likely govern this insurance contract. And if, for instance, you violate a French formality rule, like putting an exclusion clause up front and in bold print, then your clause may be void and you will not be able to rely on it. So you cannot do that. You have to adapt it to French law, and that's costly. And you don't do that occasionally. You only do that when you strategically penetrate the French market, but you don't do that occasionally just by using your freedom to provide services across borders in the European Union. So the PRICL were addressed at the legislator as a model law to be followed by the legislator. In contrast, the PRICL are clearly and only addressed at the market. They are an instrument offered to the parties, and it's their choice whether PRICL will ever be a living law of reinsurance or not. And the answer is easy. In reinsurance, you have partners that are at equal footing. They negotiate at arm's length. There's no need to protect one party by mandatory provisions. And any rule you offer to them is to their favor if they accept it. And if they do not want it to be applicable, they can, of course, not opt for it. So it's really an instrument for the markets if markets accept it. And the market will ultimately decide on the success of the PRICL. This is then leading to the question on how you implement such soft law rules. When it comes to the restatements in the US, they just have to be persuasive. Once they are persuasive, convincing, then some court in some state in the US will follow that, because why would you not follow a convincing idea? The PRICL were addressed at the legislator, so it would require a EU regulation, and soft law cannot do away with national mandatory law. And so as long as the legislator doesn't act, the PRICL will not be able to really provide this possibility for insurers to sell their insurance contracts cross-border without any adaptations to the local law. But the PRICL being addressed to the markets need to be enforced by the market, and this is done by choice of law and arbitration clauses. There is, of course, always an alternative, and in some instances, this is a good idea. You do not choose the PRICL as the law governing your reinsurance contract. You say it's Brazilian law that governs, or Swiss law, or English law, but you copy and paste them into your contract, and that means they become contract clauses. That's another option. And parties are, of course, absolutely free to go one way or the other. Now, next to an implementation of those principles, are there any other benefits? And I think there again, all three sets of soft law have the same benefits. They operate as a frame of reference in litigation and in arbitration, irrespective of whether they are soft law, hard law, or whether they are chosen by the parties as the law applicable, or whether they are incorporated into the contracts by a copy-paste method by the parties. Irrespective of all of this, they are a piece of work, of, let's say, academic work, even though it's not purely academic what's in there. It's available, you can read it, it's commented, it's illustrated, so it's a piece of work that you can use as a starting point of your discussion, as a reference for your discussion. And we see that this is being the case more recently. If you have been involved in cases now, either negotiations or even arbitrations on aggregation, for instance, with COVID-19 cases or so, we have seen that a lot of negotiations and even arbitrations refer to the PRICL, even though the contract, of course, has not chosen them as the applicable law, and from a formal point of view, they are not applicable. But they are being used as an instrument of argumentation, as a persuasive tool to the arbitrators or the legislators. And the same is true of the PRICL and the restatements in the US. They are a frame of reference. They are being referenced by the European Court of Justice, sometimes by legislators, and they are certainly referenced by US courts, as we observe in many published decisions. And one benefit that I want to point out very strongly is that they inspire research and teaching. It has been very tough for civil law students to engage in reinsurance contract law because there has been so little material. There have probably been textbooks. I'm aware that we have great textbooks also in Brazil on reinsurance, but in many countries this is completely missing. And the PRICL project has now brought about new PhD theses on specific topics of reinsurance. You may know Oliver Williams' piece on aggregation, and there is also Kevin Ward writing on follow the settlements. And this is going on. There's more students now coming up and trying to write a PhD thesis on topics of reinsurance contract law, because they have a frame of reference now, the PRICL, within which they can operate. And by the way, there's also now just published a new book on reinsurance in Turkey as well by Hakan Kocak, and that has also been to a certain extent inspired by the PRICL. And I think that should not be underestimated also for practitioners. Now, when we look at the way forward, I think it's from now on the task of academics and practitioners to use this tool in a way that in a cooperative way. And I show you here the Swiss view, and this could as well be a Brazilian view or a German or an English or a US American view, because I've mentioned here the Swiss arbitration society. That could as well be the Brazilian or any other around the globe. And what would be the task of every part of this reinsurance world? Well, I think academia would still have to go on and found something like a documentation center, a center where we make available all the publications on the PRICL, where we make available, if possible, case law on the PRICL, and where we educate by giving seminars, or as I've mentioned here, probably also moot courts based on the PRICL, very much basically like the Wismut court that is always dealing with the Vienna Sales Convention. Also, I think it is the task of academia to update the PRICL if necessary in the future. The industry, and I mean the reinsurance companies and the insurance companies, would have the task to refer to the PRICL in arbitration clauses. And if I may say so, it would be extremely helpful for the future development of the PRICL if arbitral awards would be made public, maybe in a anonymous form, but made available. That would create case law on the PRICL and would then be helpful for further arbitrations, and would avoid probably many arbitrations, and would certainly avoid deviating outcomes in arbitrations. A third point that is necessary for the industry is to compare PRICL with standard clauses that are being used, let's say in the London market, but also in other markets, and see how those standard clauses can be brought in line with the PRICL and the other way round. We have to start such a communication between those standard clauses and the PRICL. And when I mention ASA here, that refers equally to any other non-Swiss institution of arbitration. You should ask yourself, are our rules on arbitration, like here we call them the Swiss rules, apt for any reinsurance arbitrations? Do we need modifications? The Swiss rules have been amended recently for multi-party arbitrations, and that may be very important in reinsurance context, where you have layers of reinsurance cover with several reinsurers being involved. And then these institutions could offer one package solutions, like giving an arbitration clause and giving stating a clear reference to the PRICL as the law applicable to the reinsurance contract. The one package solution is reached by a very simple mean, which is that you add in your reinsurance contract a sentence like this one here. This contract shall be governed by the principles of Reinsurance Contract Law, PRICL 2024. We recommend this 2024 because there may be later versions of PRICL, and you would later on want to know on what version you based your choice of law clause. But this magic sentence will immediately lead to the consequence that that your contract will be governed as far as reinsurance specific rules are concerned by the principles of reinsurance contract law, and by way of reference, as far as issues of uniform general contract law are concerned, by the unitoire principles of international commercial contracts. And the two form a more or less complete set of rules, and you would not have to refer to any specific national law anymore. You could do so, but if you want a truly uniform and global set of rules, you would just add this one sentence and you will be fine. And this is why I usually like to express the benefit of the PRICL in this way. Reinsurance contract law, as it still stands today, is a multi-layered and complex system. Depending on the jurisdiction you're in, you will have to open many different books and read yourself into the context of each and every jurisdiction. This is why I have used this huge bookshelf as a sample. Whereas if, as of 2025 and forward on, when you refer simply with this one sentence to the PRICL, then you have a one package solution. This will be one book that's called the PRICL, and there you should be you should comprehensively find any question solved that you ask in reinsurance. That's of course the idea, and we hope that we at least get close to providing these benefits that I'm talking about. Well, that's from my side. If you have any interest for further information, and if you're looking for contact details, please use one of these links. The first one leads you to the University of Zurich, where we have the website of the PRICL project. The second one leads you to the UNITRA organization as our cooperation partner. They have another project website there, and my personal addresses and email addresses you find on the very bottom of the page. Thank you very much for having me.
Nós que agradecemos, professor, uma verdadeira aula de uma área ainda tão pujante, mas ainda um pouco desconhecida, né? Eu, particularmente, fiquei aqui pensando na publicação ou dos extratos ou das sentenças arbitrais, como isso seria feito, né? E qual o impacto que isso pode ter na previsibilidade dessas soluções. Excelente, eu acho que realmente foi uma aula sobre o PRICL e em breve teremos muitas dúvidas sobre o tema. Passando aqui, então, para os nossos especialistas que vão trazer as ponderações e perguntas, vou passar a palavra para o professor Sérgio Mello, né, para que traga aí suas ponderações também.
Bem, vamos lá, gente. Muitíssimo obrigado aí mais uma vez. Não sei se todos estão me ouvindo, mas como a gente imaginava, o professor Helmut Heiss nos fez uma magna aula sobre os princípios internacionais de contrato de resseguro, PRICL, mostrando não apenas os seus fundamentos, o seu início, uma overview ali do tempo, né, uma linha do tempo de como ele foi construído, especialmente o PRICL 1, e aí já as perspectivas para o PRICL 2, que deve estar pronto ali no próximo verão europeu. Nós temos aí mais 2 reuniões, uma em janeiro e uma outra em julho do ano que vem, nas quais a gente pretende fechar esse texto, e mostrou também, do ponto de vista prático, como se aplica a segurança jurídica que confere aos negócios de resseguro. Eu creio que foi muito bom assistir o professor Helmut Heiss, coordenador-geral do PRICL, falando sobre o assunto, para mostrar a todos os players do mercado a utilidade dessa ferramenta no âmbito jurídico, já que ela visa exatamente criar condições e facilitar as negociações quanto ao negócio jurídico de resseguro. Bem, coube a mim, dentro do tempo que nós temos aqui, sem querer tirar o tempo dos meus colegas, que certamente terão muito mais a dizer do que eu, tratar rapidamente de 3 pontos que já se encontram definidos no PRICL 1 e que me parecem de extrema importância para os contratantes de resseguro. O primeiro deles é o chamado dever pré-contratual que o ressegurado tem em relação ao negócio de resseguro. Ali na cláusula 2 do PRICL 1, nós vamos notar que diz o seguinte, que ao buscar a cobertura de resseguro, cabe ao ressegurado fornecer todas, sem exceção, todas as informações que sejam relevantes para conhecimento do ressegurador para efeito de absorção do risco e sua respectiva aceitação. Isto nada mais é do que a consagração dos usos e costumes desse negócio de resseguro, que assim funciona, mas que muitas vezes se interpreta de forma distinta. Então, é bom a gente observar que os usos e costumes eles são nada mais do que a fonte primária do PRICL. É a partir dali, como foi dito pelo professor Helmut, que se tornou ali uma referência para o nosso trabalho, trazer para o PRICL o que já existia, o que os contratantes já estavam acostumados a celebrar. No entanto, o que a gente nota, já que há um elemento muito significativo do empresário de seguro e resseguro, é a sua criatividade. Né? Sem a sua criatividade, obviamente, nós não teremos uma evolução tão maravilhosa como nós tivemos nos últimos anos. E a criatividade não pode, naturalmente, ficar longe da tradição do negócio, ficar longe dos usos e costumes. Então, esse é o papel do PRICL, e mais ainda, quanto aos deveres pré-contratuais, eu destaquei esse ponto, há diversos outros, mas que me parece um ponto a dar uma certa tranquilidade àqueles que vão negociar. Um outro elemento que me parece muito importante, que está relacionado ali à regulação dos sinistros, e aí mais até os sinistros de médio e grande porte, em relação ao próprio aviso do sinistro. Há sempre uma perspectiva, uma ideia de como isso vai funcionar. Então, o PRICL vem e no item 2.3.3, ele esclarece muito claramente que o ressegurado deverá notificar o ressegurador, e é claro que é uma notificação formal, pode até ser informal, mas de alguma maneira que gere algum tipo de prova, mas informá-lo de maneira adequada e, sobretudo, tempestiva sobre os sinistros, mas não só sobre os sinistros, sobre também as suas circunstâncias. E é o que eu sempre digo, quando ocorre um sinistro, a moeda do ressegurador chama-se informação. O ressegurador ele precisa ser alimentado de dados permanentemente. Cabe à seguradora fazê-lo, até para que ela, a seguradora, possa ter também a tranquilidade de, ao cumprir o seu dever contratual, poder também ter o direito de exigir aquelas obrigações que o ressegurador se comprometeu no contrato de resseguro. Então, fica aqui um alerta de que, mais do que nunca, o PRICL consagra a necessidade de um fluxo permanente de informações entre ressegurado e ressegurador durante todo o período de regulação e liquidação dos sinistros. E o último, e rapidamente, um ponto que me parece absolutamente tradicional, mas é justo por isso que eu queria comentar, é o artigo 2.4.3, que trata de seguir a sorte e seguir os procedimentos. Esse é um ponto tradicional, porque no mundo inteiro, historicamente, muito se discute sobre o alcance, sobre o sentido, sobre a finalidade desses princípios, que são fundamentais, em especial quando a gente tem um sinistro. E aí, então, nesse dispositivo, fica muito claro no PRICL que, na medida em que haja uma perda, o ressegurador deverá seguir as liquidações do ressegurado, isso é muito claro no texto, as suas perdas, se estiverem, no entanto, razoavelmente, indiscutivelmente, dentro da cobertura do contrato de seguro principal. Notem que a expressão principal significa daquele contrato de resseguro, de seguro que está inserido no resseguro automático ou, obviamente, o facultativo. E mais, diz lá que deve o ressegurador acompanhar toda a sorte do ressegurado. Então, para aqueles que imaginam que o PRICL poderia alterar algo no que diz respeito a esse princípio basilar do negócio jurídico do resseguro, fica aqui uma informação de uma segurança jurídica plena ao trazer naturalmente os usos e costumes, mais uma vez, para o texto, exatamente como é praticado no mundo internacional dos negócios de resseguro. Bem, Juliana, eu acho que era isso que eu tinha que falar aqui rapidamente, como eu disse, para não atrapalhar aí a fala dos meus colegas que estarão aí mostrando muito mais do que eu, mas fico à disposição de vocês e de todos aqueles que eventualmente tenham questionamentos. Mais uma vez, parabéns à Fundação Getúlio Vargas por esse belíssimo evento. Agradeço em meu nome, agradeço em nome da AIDA e agradeço em nome do PRICL, né, por nos dar esse espaço tão valioso, viu? Muito obrigado.
Professor Sérgio, nós que agradecemos aqui em nome da Fundação, com certeza esse é um seminário bem específico. Enquanto o senhor falava, né, eu acho que essa expressão aqui no Brasil é algo tão raro e tão valioso em termos quase utópicos, que é essa questão da segurança jurídica plena. E esse longo trabalho realizado por várias instituições, a Uncitral, nesse caso aqui a Unidroit, trabalhando tão profundamente na uniformização de áreas como essa, né? Nesse caso tão específica. Professor Heiss, gostaria de saber se o senhor tem algum comentário sobre os pontos trazidos pelo professor Sérgio, ou se o senhor prefere já passarmos para os outros apontamentos. O senhor manda aqui.
No, I'm not the boss. Anything but that. But no, I don't have any comments. I think that was very clear, and I appreciate the comments very much. And I think Sergio has pointed out very important parts of this set of principles, and they are as an expression of the overall Uberima Fides utmost good faith principle. They are sort of cornerstones of our project, and I think it was very good that they have been pointed out. Thank you.
Maravilha. Pelo pouco que eu trabalhei ali com esse belo trabalho feito pelos senhores, né? Com o senhor coordenador-geral, o professor Sérgio contribuiu muito aí, principalmente com a nossa perspectiva brasileira, que é peculiar sempre e delicada. Eu acho que assim, a própria forma de trabalhar a boa-fé dentro do mercado de seguros, eu acho que fica muito clara aí no trabalho de vocês. Só por isso já teria valido muito a pena esse esclarecimento para todo o mercado, a interpretação, né, das questões contratuais. Já respondendo uma pergunta que tivemos aqui no chat, em relação ao material compartilhado pelo professor Heiss, nós vamos disponibilizar pelo YouTube, tá bom? Todos os slides da apresentação para quem perguntou, aí acho que foi o Marcos, né? Então, Marcos, a gente vai disponibilizar no YouTube, tá bem? Passando aqui a palavra, então, para o nosso professor Ilan Goldberg, para que faça suas ponderações. Professor Ilan, por favor.
Bom dia a todos e a todas. Gostaria de saudar o professor Helmut e agradecer pela excelente palestra, cumprimentar os meus companheiros aí nessa nossa mesa virtual, Marcelo Mansur, e aproveito também para parabenizá-lo por tudo que vem sendo feito pelo Instituto de Seguros e Inovação, tanto a propósito desse webinar, quanto do Comitê de Seguros e Regulação, aí no âmbito da FGV. É um prazer para mim participar. Saúdo o Bernardo Arruda, Sérgio Melo e todo o pessoal da FGV, incluindo a professora Juliana, o Marcos Mendonça, que gentilmente endereçou o convite a mim, a Vanessa e aos nossos intérpretes. A gente combinou aqui e tenho duas perguntas que vou formular ao professor Helmut. Bom, a primeira diz respeito à arbitragem, à adoção dos PRICLs e ao projeto de lei número 29 de 2017, que tem a finalidade de trazer um novo marco legal para os contratos de seguro e de resseguro no Brasil. A nossa lei de arbitragem, a Lei 9.307, de 1996, em seu artigo 2º, ela viabiliza pelas partes a escolha tanto de lei quanto de jurisdição, inclusive para arbitragens que tenham a administração pública como parte. Esse dispositivo segue melhores legislações arbitrais ao redor do mundo, no sentido de, diante de direitos disponíveis, viabilizar essa dupla escolha que eu acabei de mencionar. O projeto de lei 29 de 2017, que, como eu disse, visa implementar um novo marco legal para os contratos de seguro e resseguro no Brasil, em seu artigo 127, determina de maneira compulsória a adoção de lei e jurisdição brasileira, o que seria uma exceção, considerando todos os outros mercados regulados, todas as outras atividades empresariais que no Brasil, por força da lei de arbitragem, detêm essa dupla escolha livre. Considerando, aqui vai a pergunta, professor Helmut, considerando essa restrição apontada pelo artigo 127 desse projeto de lei, como ficaria a escolha dos PRICLs como uma ferramenta no sentido de viabilizar uma interpretação mais eficiente por parte daquele encarregado da solução dessas eventuais disputas? Essa é a primeira pergunta. Eu posso já formular a segunda e aí deixo o professor Helmut à vontade com as duas? A segunda, mais simples. Em 2019, professor Helmut, nós estivemos juntos e acho que antes ainda da publicação do PRICL número 1, também aqui na FGV, e naquela ocasião eu lhe formulei uma pergunta a respeito de expectativas em torno da efetiva implementação dos PRICLs pelas partes. Um pouco antes da realização desse nosso evento aqui hoje, eu consultei alguns resseguradores dos mais relevantes em atuação no Brasil, muitos deles multinacionais, e o que eles me disseram é que no Brasil ainda não implementam os PRICLs, ao passo que na Europa o fazem. Então, a pergunta seria o porquê da ainda não implementação no Brasil e se, na sua opinião, o que deveria ser feito com a finalidade de que, se na Europa já é assim realizado, o que poderíamos fazer para, no Brasil, seguir esse mesmo passo. Muito obrigado.
Muito obrigada, professor Ilan. Então, professor Heiss, são duas perguntas, uma sobre, né, o novo projeto de lei aqui no Brasil, que vai excepcionar a questão da arbitragem na área, né, que seria uma exceção, e a outra sobre essa divergente aplicação dos PRICLs em maior escala em outros países, e aqui no Brasil ainda não. Então, acho que tem a pergunta do professor Ilan, o que poderia ser feito para que isso acontecesse com mais frequência.
Yes, thank you very much. Thank you for these questions. They are really at the core of the implementation of PRICL, and I'm very glad to answer them. The first one is something that, well, I take notice of, that in fact there is some Article 127 which provides for a compulsory application of Brazilian Reinsurance Contract Law. And if that is the case, then you cannot install a Brazilian arbitration proceeding with a choice of law in favor of the PRICL, because apparently the arbitration panel would then say, well, that violates this Article 127, and we would still go on and apply Brazilian law. Well, if they reach this conclusion, and I'm not sure, I don't know Brazilian law and I don't know this project, but if that would be the conclusion, what then would they apply? What then would they apply? They would apply general contract law of Brazil. And I assume there is no specific contract rules in Brazilian law, no hard law rules on reinsurance contracts, as it is the case with us in Switzerland or in Germany or in Austria and in many other jurisdictions. So they may apply the PRICL nevertheless, and they may apply them by saying the parties wanted them to apply. The way the parties have chosen them by a conflict rule using that party autonomy in private international law is not possible because Brazilian law forbids that. But Brazilian law most likely does not forbid to use freedom of contract in substantive Brazilian law. And this is why they will, at least in my view, apply the PRICL as contract clauses. That's not exactly the same. It has shortcomings because whenever you run into a mandatory provision of Brazilian law, the mandatory provisions take priority to contract clauses. And this is different to the situation when you apply, when you do a choice of law. The choice of law does away with the otherwise applicable law in total, including the mandatory rules. But how many mandatory rules do you have applying to reinsurance contracts? In our world, I don't know about Brazilian law, but in our world, there's, let's say, none. This is an overstatement, of course. There's always some basic principles of contract law that are mandatory. If you have so few mandatory rules, then you can apply the whole set of the principles nearly undisturbed, nearly as they are written, with very few divergences. And so the answer from my side would be, well, then you just use freedom of contract under the Brazilian civil code, Brazilian contract law, and make them contract terms. The second question, you say you're a bit enthusiastic about how Europe applies the PRICL, whereas in Brazil it is not the case yet. I think probably that's a bit over enthusiastic. It's not that all of Europe is constantly choosing the PRICL now as the applicable law, not at all. I'm unaware of cases where parties have just right out chosen the PRICL as the law governing. What companies do so far is they take parts of the PRICL and introduce them into their contracts as contract rules, using the freedom of contract within the applicable law. So let's say it's a contract subject to German law. Then they say we have freedom of contract, we can negotiate any clause, and let's say Article 3 and so on remedies, and copy them out of the PRICL and copy them into our reinsurance contract. That will help a lot because everybody will know when interpreting this contract that the parties took it out of the PRICL. They will say the parties intended to have those clauses applied as they are commented on in the PRICL. And so you can immediately use the comments and illustrations given in the PRICL for purposes of interpretation of these clauses in the contract. So this is really how it is done so far. And I understand that it has not really run into problems so far. I understand that companies tell their brokers we would like these or other principles set out in the PRICL to be introduced into our contracts. Please negotiate this with our reinsurers. And all reinsurers would, with quite no hesitation, agree to that. Even those reinsurers that are not involved in our project and potentially are unaware or not so familiar with our principles yet, there seems to be no problem to negotiate in favor of the PRICL so far. But still, it is applying them as contract clauses and in part. There's no straightforward choice of law in favor of the PRICL so far, even in Europe.
Muito obrigada, professor Heiss. São duas questões realmente no centro da polêmica e do debate, principalmente nesse momento de lei projetada aqui no Brasil. Estava conversando com o professor Ilan até para acompanhar qual é a redação desse artigo 127, como anda, e vamos acompanhar certamente aqui pelo Instituto também, para que o espaço fique o mais estimulante possível no Brasil para um ambiente de negócios, para previsibilidade e certeza aí das decisões, das formas de solução de conflito. Professor Ilan, alguma ponderação? Podemos passar para os nossos próximos debatedores.
Eu vou falar muito rapidamente sobre a resposta do professor Helmut. Fiz a pergunta, mas eu tinha algum início de resposta em mente. Se os PRICLs fossem, de fato, não soft law, me parece que a gente teria um choque, uma colisão frontal com esse artigo 127. Considerando que se trata de soft law, com a finalidade de viabilizar a interpretação de princípios, me parece que, ainda que se esse artigo 127 for efetivamente sancionado, a escolha dos PRICLs como princípios ainda assim será viável. é o que eu acho. Mas haverá as cenas aí dos próximos capítulos. Muito obrigado, era só isso. Muito obrigado.
Maravilha. Pelo que eu entendi aqui, eu acho que o professor Heiss também entende dessa forma, né? Que ainda que não seja possível implementar diretamente, acho que a inspiração e a interpretação disso como conteúdo do contrato ainda vai permanecer. Bom, na sequência aqui, vamos ao professor Marcelo Mansur para suas ponderações e perguntas. Por favor, professor Marcelo.
Obrigado, Juliana. Bem, bom dia a todos e todas. É um prazer estar aqui. Eu queria agradecer o convite para participar desse debate, parabenizar o professor Heiss sobre pelo todo o trabalho do PRICL, né? Não é só pela palestra, então é um trabalho de longa data, a gente pôde acompanhar o que ele tem feito sobre o assunto. Estou animado para ver o texto de 2024, que vai tratar de ECO e XPL, que é um tema extremamente relevante quando a gente fala de resseguro. Queria aproveitar para cumprimentar meus colegas de mesa virtual e vou começar até aproveitando o gancho da pergunta do Ilan e da resposta do professor Heiss, para tratar justamente, começar tratando desse tema, porque eu acho que o professor Heiss já devia ter a OAB de São Paulo, porque eu acho que ele já sabe direito brasileiro, né? Pelo seguinte, eu acho que o Ilan também foi muito feliz no comentário. Quando eu comecei a estudar isso, na verdade, eu comecei a me inspirar, para quem é mais antigo, vai lembrar do trabalho de Bertold Goldman sobre Lex Mercatoria. Eu sempre fui um fã de Lex Mercatoria e tentei sempre achar onde eu podia encontrar, onde eu encontro essa Lex Mercatoria, né? E eu acabei encontrando no Resseguro, e eu acabei fazendo meu trabalho de doutorado, minha tese de doutorado, sobre o direito do resseguro. E a gente, basicamente, se a gente vai olhar para trás, eu acho que, para mim, o direito do resseguro é uma experiência, era algo novo para mim, e foi uma descoberta feliz de ver que eu poderia considerar como uma lex mercatória, mas a gente tem as regras sobre Stand-by Letter of Credit, né? Crédito documentário, que a gente chama em português, e a gente tem os Incoterms, né? E aqui a gente tem que dar um passo. O professor Heiss citou aqui o direito brasileiro, mas eu citaria especificamente o artigo 4º da LINDB, que é a Lei de Introdução a Normas do Direito Brasileiro. A gente sabe, o professor Heiss falou, que existe uma abstinência legislativa no que tange a atividade não a atividade do resseguro, mas ao contrato de resseguro. A atividade do resseguro, ela é sim regulada. Mas o contrato de resseguro, ele não é regulado. E, felizmente, eu acho que aí a gente conseguiu avançar, a gente não entra numa regulamentação forte do conteúdo do contrato pelo projeto de lei, pelo PLC 29. Então, lendo o texto aqui, pegando o gancho do que o Ilan falou, eu iria justamente para o artigo 4º, onde a gente fala que, na ausência, quando omissa a lei, a gente vai para os costumes. E o que o PRICL é? A gente está colocando 200 anos de costume dentro de um texto organizado, né? Tudo isso que o PRICL está colocando, de uma certa maneira, já existe. Recentemente, não, faz uns 2, 3 anos, a gente teve uma arbitragem entre o mercado brasileiro e o mercado ressegurador, onde os árbitros, independentemente de tudo que existe, aplicaram os princípios, os costumes ressecuritários, né? Então, essa realidade já existe, né? E aí, eu vou acho que achei importante fazer esse comentário, porque a pergunta dele foi super importante, mas eu queria fazer duas perguntas para o professor Heiss, e uma delas acho que vai interessar a Juliana, que ela não falou, mas ela é a diretora executiva da FGV, Câmara de Mediação e Arbitragem, e eu vou fazer que nem o Ilan, vou fazer as duas perguntas. A primeira pergunta, eu queria entender do professor Heiss, e aqui a gente no Brasil tem uma especificidade. No Brasil, a gente tem alguma discussão sobre a efetividade da cláusula arbitral, ou a dificuldade de uma implementação de uma arbitragem ad hoc. E a gente normalmente recomenda que se use arbitragem institucional, aqui até representada pela Juliana, tá? Que são as instituições que organizam, segundo seus regulamentos, as arbitragens. E eu queria saber se no PRICL haveria alguma preferência por arbitragem ad hoc e arbitragem institucional, até porque em alguns mercados de resseguro se costuma usar as regras da Uncitral com frequência, com mais frequência do que aqui no Brasil, que a gente acaba não usando. Então, acho que a primeira pergunta para o professor Heiss seria isso. E a segunda pergunta, eu acho que eu já entendi. Então, assim, é só para confirmar. Quando a gente teve a Convenção de Viena sobre compra e venda de mercadorias, que adotou um outro sistema, não é o sistema do PRICL, ela era de adesão obrigatória para todo mundo. E o que as pessoas faziam era excluir. Eu quero excluir a Convenção de Viena. Aqui, uma das modalidades, eu simplesmente coloco no meu contrato, que eu estou adotando aqui, esse contrato vai ser interpretado pelas regras do PRICL. Assim como a pessoa pode copiar e colar as regras do PRICL como ele quiser, eu estou imaginando que ele pode dizer o seguinte: eu quero adotar as regras do PRICL, exceto tais e tais regras. O que, obviamente, gera, porque eu fico imaginando, e aqui eu pergunto para quem elaborou o PRICL, que o ideal é a obra, o conjunto da obra. E, às vezes, pegar pedaços, o que a gente chama de pieces and bits, pegar um pedacinho aqui e acolá, pode resultar num documento que não é consistente. Mas queria aqui fazer a pergunta, se estou entendendo que isso pode ser feito e se existe algum risco, o que é preferível fazer? Adota por completo, porque é um conjunto de normas, ou adotar parcialmente. Então, são essas minhas duas perguntas para o professor Heiss e, obviamente, queria parabenizá-lo pelas palavras e por todo o trabalho realizado nesse esforço hercúleo, que é trabalhar num texto com vigência. Se um legislador que faz uma lei para um país já é difícil, imagina fazer algo que valeria para o mundo todo. Parabéns pelo trabalho, professor.
Muito obrigada, professor Marcelo. Realmente, mais uma vez, aqui é um trabalho hercúleo, difícil, mas super produtivo e especial para o mercado de seguros e resseguros, que tem essa perspectiva, né? Onde você encontrou a Lex Mercatória. Encontrar, especialmente, uma tese de doutorado é algo difícil. Normalmente, nós temos desencontros nesse momento, né, acadêmico. Acho que o senhor foi muito feliz aí no tema e certamente serve todos os dias. Acho que as perguntas trazidas falam por si, né? Realmente é nosso interesse aqui saber, sobretudo por conta desse interesse nas arbitragens em setores regulados, né? E, sem dúvida, a maior prevalência, eu acho que são pouquíssimos casos que a gente conhece aqui no Brasil de arbitragem ad hoc. Então, de fato, essa é uma pergunta fundamental, considerando o contexto aqui do nosso mercado, né, de arbitragem. Professor Heiss, por favor.
Would you allow me to share my slide once more for my answer, or is that inappropriate now?
Não, pode ficar à vontade, professor. Só o senhor ir ali no mesmo ícone verde embaixo, isso, já está aparecendo aqui para nós. Pode ficar à vontade.
So you see this one slide of page 8 again. And I just wanted to answer those two questions. First of all, the rule of PRICL is it is entirely the will of the parties, whether and in what way they apply. First of all, parties need to opt into the PRICL. They will not apply by themselves. Article 111 says the PRICL apply to contracts of reinsurance where the parties have agreed that their contract shall be governed by them. As long as there is no such agreement, PRICL are out. It's the choice of the parties. Once they have opted into the PRICL, Article 113 says the parties may exclude the application of or derogate from or vary the effect of any of the provisions of the PRICL. So the entirety of the PRICL rules are dispositive and subject to the will of the parties. They may change it completely. There is advantages and disadvantages. If you change, if you exclude the application to a certain extent and so on, and you can adapt it more properly to your own needs. on the other hand, what you do with every exception that you make is you distort the system that has been created. And you know that we like to interpret rules in a systematic manner, but if parties sort of disrupt this system, then the systematic interpretation will not be as easy anymore, and the gap filling will not be as easy anymore. So you have disadvantages and advantages, and you have to judge, parties need to judge that on their own, by their own choice. Now, I've said the easiest way is to use this one sentence: this contract shall be governed by the PRICL. That's it. And what you get is the reinsurance specific rules plus the general contract law. I've heard that certain reinsurers say, I do not want UNITRA PICC. I would like my own country's law to apply as the general contract law. So they choose the PRICL, but they derogate from Article 112, which says that anything that is not governed by the PRICL will go to the UNITRA principles. And they say it will go to, let's say, Swiss law. That's one of the possibilities. That's a partial choice under private international law. And the second thing you can do is you can either choose the PRICL as such and then take out, say, the rule so-and-so does not apply in my case, or you have a specific rule, let's say on follow the fortunes, that deviates from the PRICL, and then of course the contract will take priority over the PRICL. We have mentioned before the way PRICL are applied so far, and so far we see that the parties take out some rules and copy them into their contract. And that means they take them out of the system and they lose the context and they lose a systematic interpretation. That's the downside. The advantage is very easy. In life, you usually prefer the devil that you know as compared to an angel that is unknown to you. And since we know what's going on today, it's not easy to opt completely for a new system, right? It's like day and night to opt out of the old system and opt into a new system, even if it's true that what we have done here is not something, the contents is not new. The contents is trade custom as it has been lived by the parties for so many decades now. Still, the book as such is unknown and thereby subject to doubt and hesitations and so on and so on. So I think what we will observe in the market is a step-by-step implementation. They will use a few clauses in the beginning. They will then broaden up if they have good experience, and eventually we may see that parties actually choose them in their entirety. But the answer to your second question is it's completely up to the parties. They might just have to be aware that with every choice they do, one way or the other, there's downsides and upsides of this such choice. And that's also with institutional arbitration or ad hoc arbitration. With us, there is a lot of ad hoc arbitration in reinsurance. The PRICL do not give any rule on that. I mean, it's, again, up to the parties. They will get it the way they want it. My wish would be that they would go for institutional arbitration and they would give up the idea of confidentiality, in the sense at least that in an anonymized manner, these awards in institutional arbitration could be published. That would help a lot to develop in a civil law method, reinsurance contract law, that you have actually both. You have sort of a codified system plus case law, and that would of course give much more legal certainty. And I'm aware of the fact that so far this is only a wish from my side. But I do understand that also practitioners start wondering whether it's so important that everything remains undisclosed, what's happening in arbitration. And if that's really the case, then there may be some hope for published awards in the future. And I think that will only be done if institutional arbitration is used. I think this will be the case with ad hoc arbitration. So that's why I personally prefer institutional arbitration.
Muito obrigada, professor. Estava aqui pensando, no Brasil, recentemente, a gente tem algumas discussões, alguns setores regulados passaram, né, a exigir a publicação dos extratos, e aí existe sempre a questão da dificuldade de anonimizar esses extratos dessas decisões para que também não se exponha, né, aqueles que estão submetidos à arbitragem e seguiram esse caminho também por conta da descrição e do sigilo. Mas, certamente, se caminharmos por um aumento de arbitragens ad hoc, o que eu não sei, aí é uma opinião, né? Não acredito que ainda isso seria muito pouco provável aqui no Brasil, principalmente se tivermos as alterações legislativas aí que temos, né? Eu acho que isso vai ser bem, bem difícil.
Yeah.
Passando aqui, por último, agradecendo as suas respostas, passando por último aos comentários e perguntas do doutor Bernardo, que traz aí uma perspectiva mais da prática, né, Bernardo? E pode trazer a visão da indústria, do setor, além das visões acadêmicas também já compartilhadas aqui. Por favor, Bernardo.
Bom dia a todos mais uma vez, agradecer o gentil convite aí da FGV de participar desse importante evento, com a presença de ilustres professores e amigos, em especial para discutir um tema tão importante para todo o mercado seguro e resseguro. E depois dessa excelente palestra aí do professor Helmut e das considerações dos demais debatedores, como você disse, a minha contribuição aqui, como diretor jurídico do IRB, e diante dos meus 17 anos atuando aqui na companhia, é dividir com os senhores que, de fato, infelizmente, o IRB e os demais players do mercado enfrentam com frequência decisões judiciais não técnicas, proferidas por magistrados que, por desconhecerem os conceitos dos contratos de seguro e resseguro, acabam gerando um ônus desnecessário para o mercado e acabam ignorando os termos e condições desses contratos que foram pactuados, de comum acordo e pela liberdade aí das partes. O IRB, inclusive, em todos os seus contratos de seguro, inclui a cláusula compromissória, de forma que eventuais conflitos sejam dirimidos aí por meio de procedimentos arbitrais que, buscando aí, apesar do custo, sejam decisões técnicas que respeitem esses conceitos e as cláusulas que foram pactuadas. E entendo aí, ou seja, a difícil realidade, a dificuldade de aplicação do PRICL no Brasil, mas o IRB, naturalmente, como um importante player do mercado, a gente vai continuar acompanhando o tema diante da sua importância e estimulando a aplicação futura aí nos contratos de seguro, nos procedimentos arbitrais. E acho que é isso, é parabenizar e agradecer e ratificar a importância realmente desse tema para todo o mercado. Obrigado aí pela oportunidade, parabéns, professor, pela palestra.
Obrigada, Bernardo. Vou passar a palavra para o professor Heiss e vou trazer aqui alguns meses, professor, um aditivo aqui às ponderações do Bernardo, que eu acho que fala por todo o mercado, de fato, né? Essa dificuldade de lidar com a atuação do judiciário numa área tão técnica. Eu acho que é uma situação que se repete no Brasil, não sei se o senhor sabe, mas nós temos mais de 80 milhões de processos em curso, somos campeões, né, nesse número, portanto, os magistrados, muitas vezes, eles não estão tecnicamente ou especializados naquela área, então é comum que nos setores empresariais ou muito técnicos, essa reclamação, essa dificuldade do setor de seguro, ele se replique. E aí eu queria trazer, professor, adicionando um pouco aqui, a pimenta, né, uma pergunta. Há alguns meses houve um seminário na Unidroit mesmo, e a professora Diana Serini comentou que o PRICL também pode ser uma fonte de interpretação, ele pode ser aplicado também nos processos judiciais. Só para colocar aí junto com essa ponderação do Bernardo, como é que o senhor enxerga isso também, trazer essa pergunta junto com a ponderação do Bernardo, se o Bernardo me permitir, claro.
Com certeza, obrigado, Juliana.
Well, thank you very much. I first of all would like to comment on this issue of technical areas of law like reinsurance. That's the case everywhere, I would say. And indeed, I think it's it's special in reinsurance in that there has been a handshake mentality in the past. You had contracts that were not written down or only partially written down, and you negotiated if there were any problems, and you did that. Some descriptions we have that you did it over lunch and reached some conclusion, and that so that the conflict settlement, the settlement procedure was business driven, and I think it is still business driven. When I observe settlements being done, I would still think they are business driven, but they are more and more legally driven as well. And the tendency to provide contract certainty and the requirements of compliance of reinsurance companies and many other more circumstances have changed, and you cannot have this entire handshake mentality today anymore. So you juridify the decision process to a large extent, and it doesn't have to go to arbitration or to court. Even if there's a settlement, it will be more technical than it has been in the past. And when you do a settlement that you want to be technical, you want it to be in line with the law, you need to know the law more precisely. It cannot just be a very vague principle. And in that respect, we hope that we make the scope of negotiation more narrow, in the sense that we define concepts, that we define terms, and we do not allow for very different understandings. And so the starting point of the two parties when they negotiate will be more closer one to each other. Now, there's never ever an entire legal certainty in this world. There will always be a debate about meaning of words and so on and so on. But when you live in a world where you have a rule, where you have comments, where you have illustrations, this scope of argument becomes closer. And this is why the parties will start closer to each other, and the chance for a proper negotiation and proper settlement is better. And I think that's also true in arbitration or in court cases. And this leads me to the second point that you, Juliana, have mentioned about the source of interpretation. Well, this is the way we observe that PRICL are operating already. There has been a Norwegian arbitration on an aggregation issue in the context of COVID-19, and it has been published on the internet that the Court of Arbitration was actually referring to English law and to the PRICL as the sources of inspiration in interpreting this reinsurance contract that was apparently subject to Norwegian law. But since Norwegian law apparently did not offer specific rules on reinsurance, they were looking for comparative inspirations, and they had two main sources, which is the English law and the PRICL, and those are not so different sources, because PRICL is, of course, digging on English law to a large extent as well. Not only, but clearly there's a strong influence of English law in the PRICL as well. So yes, they are a source of interpretation. They do not want to be only a source of interpretation. They want to be applied by a choice of law ultimately. But for the time being, I think that's already an advantage, that you have a frame of reference, something that you can use as a basis for your discussion of what the contract, how the contract should be interpreted. And I think that's the main function of the PRICL at the time being.
Muito bom, professor. Estava aqui refletindo e pensando dos impactos, né? O senhor trouxe aí que o espaço, inclusive de negociação, ele vai ficando mais restrito ultimamente, né? Nessa área, e mais técnico. Eu fico imaginando, a minha área principal de atuação é a mediação, fico imaginando que com a Convenção de Singapura da UNCITRAL, o próprio aumento da prática do uso desse mecanismo, que talvez possa até ser um meio de driblar um pouco as restrições impostas por um novo marco legal ou outros tipos, com o reconhecimento de acordos internacionais por meio da Convenção de Singapura. O Brasil é signatário e muitos outros países também. Eu acredito que o aumento do uso desse mecanismo de solução de conflitos pode ser muito estimulado e aprimorado também pela aplicação dos PRICLs, né? Sempre, claro, você não está aplicando a lei dentro de um acordo, dentro de uma mediação, mas ela sempre serve de interpretação para os parâmetros ali decidido pelas partes. Muito bom. Gostaria de consultar aqui aos nossos debatedores se existe algum ponto de atenção, uma ponderação, um último questionamento antes de encerrarmos aqui.
Liana, de minha parte está tudo claro. Eu agradeço as respostas do professor Heiss e a oportunidade de estar aqui. Muito obrigado.
Nós que agradecemos, professor Marcelo.
Acompanho o agradecimento aí do Marcelo. Obrigado, FGV, professor. Prazer, Ilan, Mansur. É isso. Obrigado pela oportunidade. Estamos à disposição.
Da minha parte também, Juliana, só agradecer e torcer para que no Brasil passemos a ver mais os PRICLs nos nossos contratos. Tenho certeza que isso nos ajudaria demais a evitar decisões judiciais, muitas vezes de difícil compreensão.
Sem dúvida, né? Eu acho que a lição que fica hoje, e pensando aqui já em 2024, quando virão, esse seminário, e eu acredito que outros trabalhos, aproveitando aqui para parabenizar o Instituto de Inovação em Seguros e Resseguros da Fundação Getúlio Vargas, tem um papel fundamental de trazer essa visão acadêmica e da prática aí, para que nós possamos aprender mais sobre os PRICLs, aprender mais sobre a aplicação em soluções negociadas, na influência de projeto de lei, em sentenças judiciais e também nas decisões arbitrais. Professor Heiss, o senhor gostaria de fazer alguma última ponderação?
My last comment would be a wholehearted thank you very much for having me, giving me the opportunity to spread those ideas in Brazil. And of course, it was heartwarming to me that those ideas were welcomed in such an open manner. And I hope your Article 127 will not build a wall between us, but will still allow the communication and the transmission of ideas. And I'm sure this will be the case, and I look forward to more of that.
Muito obrigada, professor. Sem dúvida, as lições do senhor aqui, que vão ficar disponíveis no YouTube, eu acho que durante os próximos meses, que serão de muito estudo na área, certamente poderão influenciar também o nosso processo legislativo, nossos debates acadêmicos. Eu finalizo aqui agradecendo a todos a participação, o preparo técnico aqui para esse nosso encontro e desejando que várias dessas discussões possam florescer em outros debates aqui em breve. Muitíssimo obrigado ao Instituto, à Fundação Getúlio Vargas e aos professores aqui presentes. Desejando aí um resto de semana produtivo a todos.